Joining me now to discuss all of this is my friend Horace Cooper, Senior Fellow with the National Center for Public Policy Research and former constitutional law professor at George Mason University. Horace, thanks for joining us.
Hey, it's great to be here.
All right, so let's get into this issue that Kavanaugh perjured himself. We just went over in the monologue the actual text of the actual code and the actual Department of Justice regulations related to perjury. And none of the questions that the Democrats claim that Kavanaugh perjured himself on were in any way, shape, or form material to his hearing.
Materiality is one of the key elements of a perjury charge. If the federal government is wishing to prosecute you for a falsehood, that falsehood can't be a misunderstanding, a disagreement, or a difference in interpretation. It actually has to be two things: relevant and material. If you get asked, did you have coffee this morning, and you have forgotten that you had coffee this morning, and you say no, it then needs to be relevant. Why is this question being asked? If the question is being asked about an issue that doesn't provide relevance, most of the time when you're talking about a perjury issue, you're going to be talking about specific data points. A date, a particular activity, a particular responsibility, a particular legal act. Did you plea on a certain day? Were you in the country on a certain day? These kinds of things, but they have to be material. You can't bring a person up and say, hey, I'm going to ask you a bunch of questions, and if any one of the questions that I ask you turns out I can show that somehow it's inaccurate, you still can't get a perjury charge. You don't bring the dog catcher in and ask him questions about taxes and then think you can trip him up and get a perjury conviction on taxes.
You know, one of the most bizarre aspects of the Kavanaugh hearing was the Democrats went out of their way to keep saying, well, this is not a criminal proceeding, it's a job interview. But they treated every aspect of it, including the FBI investigation, like it was a criminal proceeding. So I don't think you can have it both ways.
Well, you can't have it both ways. On the one hand, they absolutely treated and they insisted that the best way for this whole issue to work out is that we open up a criminal investigation. By the way, the FBI doesn't just do random investigations. They typically do criminal investigations. They, however, under statute, when it comes to background checks, they have the authority to vet particular individuals and the information that they provide. But that's on the one side, even though the left continually argued that they were insisting that the FBI engage in its investigative powers. I even heard several senators say they should be able to issue subpoenas as a way to get it. That goes well beyond a background check, and it sounds a lot more like a criminal investigation. But on the other side of the table is if, in fact, they believed that this was a job interview, there are a legion of cases in which employers have been found civilly liable for the actions that they undertook in the course of a job interview. You're not allowed to slander, you're not allowed to publicize private information, a whole host of things. You and I may think, I'm going in for a job, but I have a right and an expectation that I am not going to see in the Washington Post all of the answers to the questions that I gave. They can't have it both ways. In fact, in this case, they can't have it either way.
You know, one of the more bizarre things was Dianne Feinstein's assertion that senators lack the experience and the training to conduct interviews the way FBI agents are trained to. Well, if that's a sticking point on the nomination of Brett Kavanaugh, that senators lack the ability to conduct FBI-style interviews, How did we ever seat a Supreme Court justice before Brett Kavanaugh and before the very existence of the FBI itself?
It's so disingenuous. There is a special appropriation fund specifically to give the to give the Senate Judiciary Committee investigators funding so that professional, trained investigators are able to go out and do the kinds of background checks and investigations that are necessary in order to make a recommendation to committees. The truth of the matter is, when Democrats ran the committee, they understood and used these investigators. Even when Clarence Thomas was being considered during his confirmation battle, Chairman Joe Biden oversaw a team of investigators who worked hand in glove with information that they received from the FBI to follow up and make sure it was properly synthesized and everyone had the information that they need. For Dianne Feinstein to claim she's unfamiliar with this, unaware of this, is just completely disingenuous. It calls into question the real serious concern about whether she had knowledge of her staff or anyone else leaking this letter. If you're going to tell me that you don't know something that I know you know, it makes me doubt you about something that I might know about that you say you know about.
All right, let's move on to the issue of impeachment. Now, only one Supreme Court justice was ever impeached, and it was back in the early 19th century. What's amazing about that is they're not talking about anything that Kavanaugh did while on the court. And I find it amazing that we would allow judges to rule, to uphold, let's say, internment and segregation, and say Brett Kavanaugh's drinking and allegations from 36 years ago would be worthy to remove a Supreme Court justice who's not even made a ruling as a Supreme Court justice yet. What's amazing is the impeachment process we know is political, and for a president, it would be based on bribery, treason, high crimes, and misdemeanors. And in Article 3 of the Constitution, the phrase good behavior is mentioned for a Supreme Court justice. But can any Democrat point to any bad behavior of Kavanaugh on the bench? No, they cannot.
No, absolutely they cannot. And in fact, they don't actually want to be bound by the terms of the Constitution. Here's what they wish to say. A material, relevant criteria to be a Supreme Court justice is that you were never, ever intoxicated at any point in your life. Now, if they wish to make that claim, they're free to tell the public, but they can't find anything like that in the Constitution. My point in earlier discussing perjury, there just is no materiality or relevance to whether or not he had 2 beers or 5 beers or even 7 beers at any one given time. For them to go forward is to show that they do not accept the normal process of the American constitutional system. What we do is we bring forward a name, the Senate gets to advise and consent. If that justice during the time of their service is determined to not have acted with good behavior, they can be removed. As you point out, apparently you can rule that it's okay to grab every Japanese person on the West Coast and lock them up and confiscate their property in the name of war fighting, and have the entire nation years later have to issue checks of reparation and make an official policy. But the act itself apparently wasn't bad enough to constitute an impeachable offense. How, even if you had 5 beers or 7 beers in one setting, could that constitute an impeachable offense when it is occurring well before you've actually ever served?
One last thing. The Democrats are saying that the Republicans, led by Mitch McConnell, have destroyed the credibility of the process. This from the people who endlessly brought up things like Devil's Triangle and boofing as if it was somehow relevant to the seating of a Supreme Court justice. Just wrap with us on that one. How could these Democrats say that Republicans have destroyed the credibility of the process when they themselves brought in some of the most insane things into this hearing room?
I've said it before and I'll say it again. If it wasn't for double, the Democrats would have no standards whatsoever. It is unbelievably remarkable for them to stand and say they're upset that Brett Kavanaugh was confirmed with only a simple majority when they're the ones that set up the rules when Democrats last had control, changing the number to confirm judges. It is remarkable how when Neil Gorsuch was nominated and Neil Gorsuch was replacing Antonin Scalia, which would have had almost no change ideologically to the court, that they insisted that it was the end of the world as we know it and that they would fight tooth and nail, forcing the moderate senators, including John McCain, to agree to change the system. This is the thing that they complain about. Now I just recently hear that apparently there were more states with larger populations that voted against Kavanaugh than states with smaller populations that voted for Kavanaugh, and that therefore our constitutional system is inherently unfair. These are people that every day show they're not committed to the rule of law, and they're not committed to the constitutional design that I think is one of the most amazing documents to have ever been created in over 250 years.
All right, I got to wrap it there, Horace. Thanks so much for joining us on the program. You know we'll have you back real soon, and I look forward to having you back on radio.
Thank you.